Welcome to the appendix, where we read the primary sources of the past so the present can be better understood. Today's primary source, Cohens v. Virginia, 1821. Heir to the Quarterly Session Court of Norfolk, Virginia, P.J. and M.J. Cohen were prosecuted for selling lottery tickets in violation of Virginia statute. The defendants claimed the protection of an act of Congress of 1802 establishing a lottery, but they were convicted and fined in the Virginia court. The defendants sued out of a writ of error to the Supreme Court under Section 25 of the Judiciary Act of 1789. This case involved the constitutionality of that section and the interpretation of the 11th Amendment to the Constitution. Marshall, Chief Justice. First, the first question to be considered is whether the jurisdiction of this court is excluded by the character of the parties, one of them being a state, and the other a citizen of that state. The second question of the third article of the Constitution defines the extent of the judicial power of the United States. Jurisdiction is given to the courts of the Union to two classes of case. In the first, their jurisdiction depends on the character of the cause, whoever may be the parties. This class comprehends all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made, or which shall be made, under their authority. This clause extends the jurisdiction of the court to all the cases described without making in its terms any exception whatever and without any regard to the condition of the party. If there be any exception, it is to be implied against the express words of the article. In the second class, the jurisdiction depends entirely on the character of the parties. In this are comprehended controversies between two or more states, between a state and citizen of another state, and between a state and foreign states, citizens or subjects. If these be the parties, it is entirely unimportant what may be the subject of controversy. Be what it may, these parties have a constitutional right to come into the courts of the Union. A case in law or equity may truly be said to arise under the Constitution or a law of the United States whenever its correct solution depends on the construction of either. The jurisdiction of the court then being extended by the letter of the Constitution to all cases arising under it and under the laws of the United States, it follows that those who would withdraw any case of this description from that jurisdiction must sustain the exemption they claim on the spirit and true meaning of the Constitution, which spirit and true meaning must be so apparent as to overrule the words which its framers have employed. The counsel for the defendant in error have undertaken to do this, and have laid down the general proposition that a sovereign independent state is not suable except by its own consent. This general proposition will not be controverted, but its consent is not requisite in each particular case. It may be given in a general law, and if a state has surrendered any portion of its sovereignty, the question whether a liability to suit it be a part of this proportion depends on the instrument by which the surrender is made. If, upon a just construction of that instrument, it shall appear that the state has submitted to be sued, then it has parted with the sovereign right of judging in every case on the justice of its own pretensions, and has entrusted that power to a tribunal in whose impartiality it confides. The American states, as well as the American people, have believed a close and firm union to be essential to their liberty and to their happiness. They have been taught by experience that this union cannot exist without a government for the whole, and they have been taught by the same experience that this government would be a mere shadow that must disappoint all their hopes unless invested with large portions of that sovereignty which belongs to independent states. Under the influence of this opinion, and thus instructed by experience, the American people, in the conventions of their respective states, adopted the present Constitution. If it could be doubted whether, from its nature, it were not supreme in all cases where it is empowered to act, that doubt would be removed by the declaration that this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, of which shall be made, under the authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the Constitution or laws of any state to the contrary notwithstanding. This is the authoritative language of the American people, and if gentlemen please, of the United States. It marks, with lines too strong to be mistaken, the characteristic distinction between the government of the Union and those of the states. The general government, though limited as to its objects, is supreme with respect to those objects. This principle is a part of the Constitution, and if there be any who deny its necessity, none can deny its authority. To this supreme government ample powers are confided, and if it were possible to doubt the great purposes for which they were so confined, the people of the United States have declared that they are given in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to themselves and their posterity. With the ample powers confided to this supreme government for these interesting purposes are connected with many express and important limitations on the sovereignty of the states, which are made for the same purposes. The powers of the Union on the great subjects of war, peace, and commerce, and on many others, are in themselves limitations of the sovereignty of the states. But in addition to these, the sovereignty of the states is surrendered in many instances where the surrenderer can only operate to the benefit of the people, and where perhaps no other power is conferred on Congress than a conservative power to maintain the principles established in the Constitution. The maintenance of these principles in their purity is certainly among the great duties of the government. One of the instruments by which this duty may be peacefully performed is the judicial department. It is authorized to decide all cases of every description arising under the Constitution or laws of the United States. From this general grant of jurisdiction, no exception is made of those cases in which a state may be a party. When we consider the situation of the government of the Union and of a state in relation to each other, the nature of our Constitution, the subordinates of the state governments to which that Constitution, the great purpose for which jurisdiction over all cases arising under the Constitution and laws of the United States is confined to the judicial department, are we at liberty to insert in the general grant an exception of those cases in which a state may be a party? Will the spirit of the Constitution justify this attempt to control its words? We think it will not. We think a case arising under the Constitution or laws of the United States is cognizable in the courts of the Union, wherever may be the parties to that case. Had any doubt existed with respect to the just construction of this part of the section, that doubt would have been removed by the enumeration of those cases to which the jurisdiction of the federal courts is extended, in consequence of the charter of the parties. In that enumeration, we find controversies between two or more states, between a state and citizen of another, and between a state and foreign state, citizen, or subjects. One of the express objects, then, for which the judicial department was established is the decision of controversies between states, and between a state and individuals. The mere circumstance that a state is a party gives jurisdiction to the court. How then can it be contended that the very same instrument in the very same section should be so construed as that this same circumstance should withdraw a case from the jurisdiction of the court where the Constitution or laws of the United States are supposed to have been violated? The mischievous consequences of the construction contended for on the part of Virginia are also entitled to great consideration. It would prostrate, it has been said, the government, and its laws are the feet of every state in the Union. And would not this be its effect? What power of the government could be excluded by its own means in any state disposed to resist its execution by a court of legislation? The laws must be executed by individuals acting within the several states, if these individuals may be exposed to penalties, and if the courts of the Union cannot correct the judgment by which these penalties may be enforced, the course of the government may be, at any time, arrested by the will of one of its members. Each member will possess a veto on the will of the whole. Different states may entertain different opinions on the true construction of the constitutional powers of Congress, but a constitution is framed for ages to come and is designed to approach immortality as nearly as human institutions can approach it. Its course cannot always be tranquil. It is exposed to storms and tempests, and its framers must be unwise statesmen indeed if they have not provided it, so far as its nature will permit, with the means of the self-preservation from the perils it may be destined to encounter. No government ought to be so defective in its organization as not to contain within itself the means of securing the execution of its own laws against other dangers than those which occur every day. Courts of justice are the means most usually employed, and it is reasonable to expect that a government should repose on its own courts rather than on others. There is certainly nothing in the circumstances under which our Constitution was formed, nothing in the history of the times, which would justify the opinion that the confidence reposed in the states was so implicit as to leave in them and their tribunals the power of resisting or defeating in the form of law the legitimate measures of the Union. It has been also urged as an additional objection to the jurisdiction of the court that cases between a state and one of its own citizens do not come within the general scope of the Constitution, and were obviously never intended to be made cognizable in the federal courts. If jurisdiction depended entirely on the character of the parties, and was not given where the parties have not an original right to come into court, that part of the second section of the third article which extends the judicial power to all cases arising under the Constitution and laws of the United States would be mere surplusage. It is to give jurisdiction where the character of the parties would not give it, that this very important part of the clause was inserted. It may be true that the partiality of the state tribunals in ordinary controversies between a state and its citizens was not apprehended, and therefore the judicial power of the Union was not extended to such cases. But this was not the sole nor the greatest object for which this department was created. A more important, or much more interesting object was the preservation of the Constitution and laws of the United States, so far as they can be preserved for judicial authority, and therefore the jurisdiction of the court of the Union was expressly extended to all cases arising under that Constitution and those laws. If the Constitution or laws may be violated by proceedings instituted by a state against its own citizens, and if that violation may be such as essentially to affect the Constitution and the laws, such as to arrest the progress of government in its constitutional course, why should these cases be expected from the provision which expressly extends the judicial power of the Union to all cases arising under the Constitution and laws? After bestowing on this subject the most attentive consideration, the court can perceive no reason founded on the character of the parties for introducing an exception which the Constitution has not made, and we think that the judicial power as originally given extends to all cases arising under the Constitution or a law of the United States, whoever may be the parties. This leads to the consideration of the 11th Amendment. It is, then, the opinion of the court that the defendant who removes a judgment rendered against him by a state court into this court for the purpose of re-examining the question whether that judgment be in violation of the Constitution or laws of the United States, does not commence or prosecute a suit against the state, whatever may be its opinion, where the effect of the writ may be to restore the party to the possessions of a thing which he demands. But, should we, in this, be mistaken, the error does not affect the case now before the court. If the writ or error be a suit in the sense of the 11th Amendment, it is not a suit commenced or prosecuted by a citizen of any other state or by a citizen or subject of any foreign state. It is not then within the amendment, but is governed by the Constitution as originally framed, and we have already seen that in its origin the judicial power was extended to all cases arising under the Constitution or laws of the United States, without respect to parties. Second, the second objection to the jurisdiction of the court is that its appellate power cannot be exercised in any case over the judgment of a state court. This objection is sustained chiefly by arguments drawn from the supposed total separation of the judiciary of a state from that of the Union and their entire independence of each other. The argument considers the federal judiciary as completely foreign to that of a state, and has been no more connected with it in any respect whatever than the court of a foreign state. If this hypothesis be just, the arguments founded on it is equally so. But if the hypothesis be not supported by the Constitution, the argument fails with it. This hypothesis is not founded on any words in the Constitution which might seem to countenance it, but on the unreasonableness of giving a contrary construction to the words which seem to require it, and on the incompatibility of the application of the appellate jurisdiction to the judgment of state courts with the constitutional relation which subsists between the government of the Union and the government of those states which compose it. Let this unreasonableness, this total incompatibility, be examined. That the United States form, from many and for most important purposes, a single nation, has not yet been denied. In war, we are one people. In making peace, we are one people. In all commercial regulations, we are one and the same people. In many other respects, the American people are one, and the government which is alone capable of controlling and managing their interests in all these respects is the government of the Union. It is their government, and in that character they have no other. America has been chosen to be, in many respects, and to many purposes, a nation, and for all these purposes her government is complete. To all these objects it is competent. The people have declared that in the exercise of all the powers given for these objects it is supreme. It can then, in effecting these objects, legitimately control all individuals or governments within the American territory. The Constitution and laws of the state, so far as they are repugnant to the Constitution and laws of the United States are absolutely void. These states are constituted parts of the United States. They are members of one great empire, for some purposes sovereign, for some purposes subordinate. In a government so constituted, it is unreasonable that the judicial power should be competent to give efficacy to the constitutional laws of the legislature. That department can decide on the validity of the Constitution or law of a state if it be repugnant to the Constitution or to a law of the United States. It is unreasonable that it should also be empowered to decide on the judgment of a state tribunal enforcing such unconstitutional laws. Is it so very unreasonable as to furnish a justification for controlling the words of the Constitution? We think it is not. We think that in a government acknowledgedly supreme, with respects to objects of vital interest to the nation, there is nothing inconsistent with sound reason, nothing incompatible with the nature of government in making all its departments supreme, so far as respects these objects, and so far as necessary to their attainment. The exercise of the appellate power over those judgments of the state tribunal which may contravene the Constitution or laws of the United States is, we believe, essential to the attainment of those objects. The propriety of entrusting the construction of the Constitution and laws made in pursuance thereof to the judiciary of the Union has not, we believe, as yet been drawn in question. It seems to be a corollary from this political axiom that the federal courts should either possess exclusive jurisdiction in such cases or a power to revise the judgment rendered in them by state tribunals. We are not restrained, then, by the political relations between the general and state governments from construing the words of the Constitution defining the judicial power in their true sense. We are not bound to construe them more restrictively than they naturally import. They give to the Supreme Court appellate jurisdiction in all cases arising under the Constitution, laws, and treaties of the United States. The words are broad enough to comprehend all cases of this description in whatever court they may be decided. After having bestowed upon this question the most deliberate consideration of which we are capable, the court is unanimously of opinion that the objections to its jurisdiction are not sustained, and that the motion ought to be overruled. Motion denied. After the jurisdiction of the court was thus established, the case was then heard and decided on its merits. The court held that the act of Congress authorizing the lottery was confined in its operation to the city of Washington, and gave the defendants no right to sell lottery tickets in Virginia, and that the Norfolk court therefore had the right to convict the defendants for violating a law of Virginia, and its judgment was therefore affirmed. Thank you for joining us for our primary source today on the appendix. We will see you in the stacks.